Welcome to Let's Talk with Aaron Johnson, Episode 8, Separation of Powers and the Constitution. Now, we know that this has been a discussion for quite a while because we know that there are certain parts of the government that aren't real thrilled with the branches. Now, we're going to get into what the founders, what the people that actually wrote the Constitution had to say about this. But before we do that, let's go ahead and talk about a discussion that occurred in 2016 with then Justice of the Supreme Court, Sandra Day O'Connor. Now, there were several speakers at this discussion. It was for the libraries, the Presidential Libraries Commission. So let's get in here and let's see what they had to say about this. This is Alan Brinkley. This is what he had to say about it, and he was deliberating on the influence of the Supreme Court on civil rights. At the time he was the provost of Columbia University, and he commented that the Supreme Court is in some respects the most respected of all our governmental institutions. Yet, at the same time, as we know from our own recent history, the court is also always the center of controversy. And he's not wrong in that. Seriously, it has the Supreme Court, by the Constitution, has no, we'll say, teeth, okay, in the fact that although it interprets the laws and it interprets the intentions of the other departments and it interprets the Constitution, when it's all said and done, it has no way to ensure that what we want it to do, it's actually doing. It can't enforce its own ruling. We'll get into that because actually President Andrew Jackson, kind of what he told him. It's what he kind of told him. He said now he needs to enforce his ruling. He's right, but again, it comes back to separation of power. So let's go on here. Now, in this same discussion, Justice O'Connor gave examples of 4 classic confrontations between the presidency and the Supreme Court, beginning with Thomas Jefferson and Chief Justice John Marshall, which led to the landmark Marbury versus Madison decision with its impact on judicial powers. And that was a huge case. It was probably one of the most important Supreme Court cases because it was really kind of interesting because the Supreme Court actually limited their own powers with that decision. They said that it was they gave them that they had been given too much power, and that was unconstitutional. Interesting, it really was. And then O'Connor also spoke of President Lincoln's battle with Chief Justice Roger Taney when Lincoln suspended the right of habeas corpus during the Civil War. Which, as much as what he was dealing with was important, you really, habeas corpus is kind of the basis and the foundation, and one of the reasons why we fought our Civil War, fought our Revolutionary War anyway, because without habeas corpus, you can just be arrested and you go to jail, and it doesn't matter what there's no trial by jury, there's no nothing. They don't have to tell you why they arrested you. Dangerous position to be in, dangerous position to advocate. Even if you like Abraham Lincoln, at the time there was decisions made, and who doesn't make those decisions, right? So yeah, there it is. So it was a little bit weird. So then she also went on to talk about FDR's court expansion plan, from which she said the court emerged larger in influence, if not in numbers, and much more keenly aware of its sometimes tenuous but always interesting relationship with the presidency. And that is a direct quote from Ms. O'Connor. And then, of course, she also referred to Harry Truman's 1952 seizure of the Youngstown steel mills when he expected the Supreme Court to back him, but the Supreme Court surprised him by not backing him. Interesting situation. So, but talking about all these things and how the presidency and the Supreme Court kind of battled each other, that's two of the big parts of the three-part government, right? Exactly. Now, she did end on an optimistic note. She said, as we face the trials we do today, and we have some major ones with separation of powers issues, I think we can find hope in the dignity with which the presidents and the judiciary have emerged from even the rockiest episodes of the past. So, in other words, what she's saying is that even though the presidency and the Supreme Court go head to head a lot of times, they still do so with dignity. And she is saying that she's expecting that same thing to happen now. And she's not wrong there. So that's a good thing. And so let's go on and see what else is mentioned about separation of powers. We've heard what Ms. O'Connor had to say. We've also seen what Alan Brinkley had to say. So let's see what some of the other people had to say at this convention. So let's see what else. So they were discussing several different topics during this thing. So Anthony Lewis, a former New York Times columnist, when he was comparing presidential powers during World War II and the present war on terror, he said that he felt that the assertions of unilateral executive power have a unique danger that we ought to care about. Totenberg and Nolan said the comparison turned on an unspoken factor. In World War II, the war was perceived to have an end in view. Nolan said that the far-reaching effects today make it different from any other period. And he's right. The war on terror is a unique war in the fact that there's not just one perceived enemy or an alliance of perceived enemies. It's, in a certain location, they have them everywhere. And it makes it very difficult to deal with what needs to happen, and how you go about it. Like with World War II, we had Germany and its allies in Europe, and then we had Japan in the Pacific. So we had very specific enemies, and we chose how to deal with those by the people that we had to fight. So it's very, very interesting, their take on this, but he's not wrong. But because during World War II, we find that the presidency expanded, but not in a positive way, not all in a positive way. During World War II, we had the only time that we've had a president elected more than twice. He was actually elected 4 times. So we have all of these issues that grew out of World War II, and then we take those issues and we make them even tougher and stronger and more freedom-grabbing during the war on terror from the executive branch. So yes, he's very much correct in that it is very disconcerting and something that we should be talking about, obviously. But then they go on with checks and balances, which is the concept that helps keep the separations of powers in the Constitution the way they have it set up. The concept of checks and balances is one of the ways that we do that, and it's technically the only way, because some of the branches have no power to control what's going on. So let's see what they say here. So John Q. Barrett, who is a St. John's University law professor, when he was discussing system of checks and balances, he said he felt that many members of Congress today, this was in 2016, do not recognize their role in the separation of powers. And when he was asked by other members on how the government can avoid allowing perceived threats to lead to things we're going to be ashamed of, he said the short answer is we won't know until later. So, in other words, we have to make the decision. We have to do what we have to do, and then we're going to have to deal with the consequences. And that's the thing we found in our history, that we've had to continually do this. The way we dealt with the slavery issue, the way we dealt with the Native American issue, the way we dealt with immigrant issue in the late 1800s, early 1900s, the way we dealt with the Industrial Revolution, and the way we handled dealing with all of the alcohol, prohibition, the way we've dealt with many things. We have figured out that, okay, we did it this way. It wasn't the best choice. I mean, that's why we have one amendment that prohibits the sale of alcohol. And then, within a few years, we have another amendment that says, all right, that amendment was trash. Let's just go on back to the way things were. But at this point, it was already too late, because we had allowed a criminal element to take that over, and they became strong off of that, and we've never been able to eradicate it. So that's just a prime example of something that we thought we knew what we needed to do, but we really didn't. We didn't know what we were doing with it. So it's very interesting in that respect. So he's very right on that. And, a lot of times we don't know until later. And he goes on to explain, when the executive branch fails, this is his thoughts. When the executive branch fails, I think it is when it stops looking at its watch. When it says, we're on a course, this is our course forever, the stakes are always the same. That's when and he's very right, because when we do something, as when the executive branch makes a decision, and then they say, we're never changing from this ever again, that's when they start to fail. That's when failure is imminent and probably is going to happen, just simply because that's just the way it is. So that's why we have to always continually change things. And that's one reason why having having a presidential election every 4 years is a great thing, because it can help change the momentum of the executive branch along the way. So I like his comments. So now we've kind of covered some of legal scholars and legal minds think on the separation of powers and the system of checks and balances. So now let's step on and see what the Founding Fathers had to say about it. Do we think, they're the ones that came up with this idea of separation of powers, although it is technically not listed as separation of powers in the Constitution. At no point will you find in the Constitution the phrase separation of powers, nor will you find the concept of checks and balances. as words. What you will find is what they decided and what they thought and what they did. That is what you will find in the Constitution. So let's take a look at what they thought, starting with Federalist Paper number 47. Now, the author of this one was James Madison. And if you don't know anything about the Federalist Papers, let me give you a little history on this, and this is really cool. I think I discussed this in episode 7, or one of my other previous episodes. The Federalist Papers are written by, we had the document prior to the Constitution, and that's the Articles of Confederation. And the problem with the Articles of Confederation is it established a very weak central government, which was kind of the point when they first did it, because, at the time they wrote this, we were still fighting the Revolutionary War, and we were fighting against a very strong central government, the King of England and the English monarchy and their form of government. So we developed the thing where the states had more control over themselves than the federal government did. Now, once we had won the revolution, then we realized that this was not something that was going to survive. It couldn't. When you have at least 13 separate governments trying to tell the federal government what it's going to do. So therefore, they went back to the table. They called them all back in, and they created the Constitutional Convention. And that is where, but that's where they came up with the Constitution of the United States. And they worked on this Constitution for a very long time. And the first 10 amendments were parts that they wanted to add to the Constitution from the get-go. But if you read the Constitution, there's not a lot that has to, the original parts of the Constitution are mainly about the different branches of the government and how they operate and how they do certain things. But if you notice, none other than, like in the preamble, there's really nothing that talks about the rights, except that you cannot, that there are certain rights that you can't legislate out, period. Okay. So then what they decided, in order to get this Constitution and not weigh it down and not water it down in its growth form and in the part that would help establish the government, they made an agreement that after they passed this Constitution, then they would meet and they would add a Bill of Rights, which is the first 10 amendments to the Constitution. They would add those at a later date, of course, and that's why they wrote into the Constitution on how to amend it, how to add amendments to the Constitution. So it's very interesting how they did this. They prepared the Constitution to change with the times. What other government and founding document do you know that does that? There isn't any. There isn't any. That's what makes the United States of America such a unique country. The men who wrote our founding documents and wrote the one document that our entire country is based on and our entire system is based on, did so in mind that they didn't know the future, but they knew this form of government would survive and do well. But they also wrote into it where you could make changes as changes needed to be made. Hence, I mean, because think about it, had they not done this, then you would have no rights to say what you want to say. You'd have no rights to own firearms. You'd have no rights to be able to go to church without the government telling you which church to go to. That's just three of them. Okay. You could be arrested and they wouldn't have to tell you anything else. They wouldn't have to tell you why they arrested you. You just made somebody mad, they arrest you. So these are things, and without being able to change the Constitution, there would still be slavery in this country, because it's written in there that 2/3 or a individual of color is 3/5 of a human, 3/5 of a person, 2/3 of a person. I can't remember the exact wording of that. But then we had to change it. But we wrote into it. They wrote into it how to change it so that it became a legitimate thing to talk about. Very exciting. Very exciting. So going back to this, we may have digressed a little bit, but it was something that needed to be discussed. So then, with that being said, after they wrote this, there was some that went to the convention that disagreed with the Constitution, and they began to write papers called the Anti-Federalist Papers. States' rights is top. States' rights is all we need. This is going to lead to a monarchy. This is just some of the arguments that they had in the Anti-Federalist Papers. And then in the Federalist Papers, and these were letters written to newspapers, because back then that's how people, they didn't have cell phones. That's how people got their information, was through newspapers. So letters to the editor is how they got a lot of their stuff done. So the Federalist Papers were written by people who backed the Constitution, backed adopting the Constitution, and they argued back and forth with the people from the Anti-Federalist Papers who wrote those. And what's really funny is if you read these papers, neither side was very far off. It was all in the approach on how they wanted to do it. Really was a lot of what they argued about. The Anti-Federalists really wanted stronger states government over a federal government. They wanted a weaker federal government to prevent a fight like what they had just gone through with the Revolutionary War with England. Makes perfect sense, right? But I mean, could you imagine now, today, having 50 different governments trying to tell us how to do things? And that's one reason why the Constitution says that we can't, that one state can't pass a law that interferes with the work of another state. That's why we have to have a strong federal government. And that's what Federalist and Anti-Federalist Papers were all about, was arguing for and against the adoption of the Constitution. So, having said that, and we've gone way out of board, but we needed to have this discussion. So, let's look at Federalist Paper number 47. The author of this one was James Madison, who eventually became a president of the United States, believe it or not. This paper is titled The Particular Structure of the New Government and the Distribution of Power Among Its Different Parts. They weren't very imaginative on their titles, were they? Not very imaginative at all. So now we are here, and this is where we'll end this episode, so that we can come back and pick up and discuss Federalist number 47 in its entirety without breaking up that discussion. So hang tight, and we'll be back for part 2.